Sarah Dowie.
Speaker, thank you very much. I rise in opposition to the Official Information Parliamentary Under-Secretaries Amendment Bill in this first reading. And look, I acknowledge what the sponsoring member says with respect to the concept of transparency. But when we're talking about this bill, official information with respect to parliamentary under-secretaries, I think that he's blurring the lines between parliamentary work and executive work. And I think that that is a slippery slope, and obviously that's one that the government opposes. So to put this assertion into context, and with respect to this bill, I do need to acknowledge the importance of the Official Information Act, and it is significant with respect to its intent, its purpose, and with respect to the functions that it sets out in its principles as to accountability. But that is also a balance between transparency and privacy. So, Mr. Speaker, given that I've got great respect for the principles of the Official Information Act, I've chosen a few key words from that sum it up really nicely, and that's about availability of and access to information, effective participation and administration of laws and policies, accountability of ministers, as the sponsoring member has mentioned, and officials, promotion of good government, which is something we believe in this side of the House, a balance between public interest to that information and privacy. And I believe that we have got that balance right at the moment. And I believe in this Act because once upon a time, in a previous career, I was a government official, and it was my responsibility to administer official information requests also. And I'll talk a little bit more about that shortly. But the Official Information Act, the Parent Act that this bill seeks to amend, goes to the heart of the principles of natural justice about giving the public of New Zealand the right to access information so that they can build a case with respect to their circumstances in line with a particular policy or practice, so that they can fully understand the reasons for a determination on a policy and assess whether that was a proper decision, whether that was made without bias, and if it was made fairly. But in the same breath, officials need to have the right to have free and frank conversations as to debate outcomes. And that goes toward better decision making, and sometimes those conversations do need to be protected. And then, Mr. Speaker, something that in my previous role I experienced as then the vexatious litigants, but that's probably another story for another day. But certainly as an official, with respect to the Parent Act that this bill seeks to change, I felt a quiet pressure, a healthy intensity to make me as an official accountable, the department accountable that I worked for, and ultimately the Minister and Executive Council is accountable. Parliamentary Under-Secretaries are not part of the Executive Council. The Executive Council is ministers inside and outside of Cabinet, with the Governor-General presiding over it. So parliamentary secretaries do not have a warrant. They are responsible to the designated minister, and they do the minister's bidding, and that's set out by the relevant minister. So the line of accountability rests with that minister. The line of accountability, I'll say that again, rests with that minister, and all information relating to that role can be accessed through the minister's office. And that's one that has appropriate resourcing and systems in place to meet statutory criteria of processing that request, assessing it and communicating it appropriately within the timeframes required. It would be a slippery slope if we were to enter parliamentary Under-Secretaries set out in the bill, making them subject to the Official Information Act. It's blurring the lines, again, as I said before, between the Executive Council and parliamentary functions. So what would be the ramifications of that? What would be next if parliamentary Under-Secretaries were included? What, members of Parliament next? And all the parliamentary side of work that goes with that. Members of Parliament's communications, unless they're directly with a minister's office, are not subject to the Official Information Act, and that's for good reason. We all know, we all have constituents that come to us every day and find themselves in a situation, whether it be through deliberate actions or unwitting actions, that put them in a precarious position with respect to the law. Now, if that's all subject to the OIA, then how can we do our job effectively if our constituents are fearful to disclose all of the information to their case? It's like a lawyer-client privilege. It's there for a reason. To ascertain true facts, there needs to be full disclosure. And there's all types of examples, Mr. Speaker, that come under that. But with respect to this bill, it is about parliamentary Under-Secretaries. And as I said before, the information of parliamentary Under-Secretaries can be obtained from the Minister because of the line of accountability. The relevant Minister tells the parliamentary Under-Secretary exactly what they can and can't do. There is no separate warrant. The information pertaining to the role can be directly sourced from the Minister's office. I need to talk about accountability, and that comes to the role of the Office of the Ombudsman, and the sponsor of the bill and I sit on the Government Administration Committee, and we have had a chance to review the Office of the Ombudsman, and they are the overseers, of course, that go toward that accountability under the Official Information Act. And I believe that it is well administered. Not only is that the place where people, the public, if they are aggrieved about the outcome of their request for official information, go, but if it isn't processed within the time frame, this is where those constituents go. And the Ombudsman looks at that, assesses that, and makes a ruling. They are independent and they are impartial. And so their job is a significant one. It's a checks and balances for the Executive Council and all that goes with that work. Just to wrap up again, that, Mr. Speaker, this bill seeks to amend the Parent Act, the Official Information Act, by including parliamentary Under-Secretaries, and it's simply not necessary. The Official Information Act at this stage is fit for purpose. Recently, we had technical amendments through the Statutes Amendment Act that modernised the Official Information Act, allowing for requests to be made verbally and requests to be delivered electronically. It was an opportunity to update that Act and have a look at its functioning. And the Act is within a suite of vehicles that hold the government to account. So, look, funnily enough, this is an approach that is one that was consistent with the Helen Clark Labor-led government in 2002 when she appointed 2 parliamentary Under-Secretaries. And so I say what's good for the goose is good for the gander, and there is no need for this bill.